right, please be seated. So you may proceed with your witness. All right, please be seated. So you may proceed with your witness.
Mr. Roberts, tell the jury about that traumatic event, 2013.
I was living at Economy Lodge, now Hotel 6 on Brown Road with two female friends of mine. And I was babysitting one of the females' baby. So she got worse, she came and got the baby. And it was like on a Saturday. So usually on Saturday we get together and drink a little beer, you know what I'm saying? Like me and Bill pretty much stand around and just, you know. So I came out and I went to CVS. When I came out, it was a police car at the parking lot. So I ain't paid no attention. I walked on to CVS. I went to CVS to get me some Reese cups. So I went and bought Reese cups, trying to buy Reese cups. So the police came to CBS, they was like, what's your name? And I told them. They was like, you got an ID? So I gave my ID, still standing in line. They was like, well, come step outside. So when I got outside, they took my stuff out of my back pocket, put handcuffs on me, and put me in the back of the police car. They informed me that they was looking for somebody that had robbed. They didn't say robbed nothing. They said they were looking for somebody, a suspect, I want to say. And they showed me pictures of people, and I was like, well, yeah, I know him. So they were like, where you live at? I said, room 109. I said, but the room is not in my name. They was like, D-man, we go search the room. I said, the room is not in my name. You can go search my stuff. So they went, they searched my stuff. I'm still in the back of the police car. So a few minutes later, one of the investigators walked through the car, and he was like, well, we're going to let you go in a minute. I was like, man, what's going on? You know, I ain't done it. He was like, well, we're going to let you go in a minute. Then about 2 minutes later, everybody ran and went to the hotel and up the stairs out of my view. So I'm in a police car with a motor running right here. Evidently, the door was open because the person jumped in there. It was like a car on this side, a car on this side. I was in the middle car. So a couple minutes later, I hear gunshots. I look up and I see this guy coming around the corner. I don't really know exactly where he came from, but according to the report, he came around the corner. And he pointed his gun down the wall and he shot 2 times. And he came down the steps and he went to the car to my left. He tried the door on the driver's side and it was locked. He came to the car I was in and he tried the door opened. He got in the car, put it in gear and did it.
Okay, when you make your hand motion like that, it's record doesn't pick it up, so.
I'm saying he left, he put it in gear and he drove off. He went up Burner Road towards Tony Boulevard.
Are you still in the back seat?
In handcuffs, yes, sir. So he went up the road towards Tony Boulevard, and I'm talking to him. When he came to the car and he tried the door, I was like, "Hey man, open my door and let me out." And he didn't say nothing to me. He just got in the car. So I'll talk to him. You know what I'm saying? Because I mean, I'm in the back seat. He got a gun. You know. So in the process of him driving, he went up Burner Road toward Tony Boulevard. He made a right on Tunnel, and then he made a left up through the car wash, and he came back out on Burner Road. He went back east on Burner toward the hotel. He went past the hotel and got to Chick-fil-A. He drove up in the driveway to Chick-fil-A and went the wrong way. They tried to box him in. He went across the sidewalk, went down, he made a right.
Who tried to box him in?
The police, Chattanooga police.
Okay, so the police chasing?
Yeah, so they fell right behind us as soon as we left the parking lot. They was behind us. When we made the right by CBS to go up Burner Road, they was behind us. So they were behind us the whole time, pretty much. So when we turned up in the parking lot of Chick-fil-A, he went across the sidewalk back out into Burner Road and made a right and went up Burner Road. And I was like, he said something about the freeway. I said, damn, bro. He said something about the freeway. I was like, well, he'll make a right here. So he made a right on East Brand. Then we got to the freeway. I said, where you trying to go? He said, I'm trying to go south. I said, the freeway right here. I got the freeway and went south. You know. So he drove at highway speed until he got to Dalton, Georgia, and they did a pit maneuver. Well, not a pit maneuver, they throw the spike strip out. The officer acted like he was going to throw the spike strip out. And when he swerved, he ran in front of the car and threw it out. So now the police car on all 4 flats. But now instead of going south, we're going north in the south lane. So there was a truck coming down the ramp, and he went up the ramp. So when he was going toward the truck, I laid down in the back seat. And when we passed, all I remember is when the car stopped, I raised up and he stuck the gun in his face.
Okay, you made a motion with the.
Yeah, he put the gun in his mouth and killed himself.
Yeah.
Or up on his chin. He put it somewhere in this vicinity and shot himself.
And you were in the back seat all the time?
Yes.
You know how long that lasted, how long that took?
I mean, as long as it took him to get from Chattanooga to Dalton, Georgia at 100 miles an hour. And then when I was in Dalton, Whitfield County Chattanooga had Whitfield County hold me in their custody. So a couple hours later, maybe the GBI and TBI came and talked to me. And they were like, what it was I rented a hotel room for somebody that knew the girls that I was staying with.
Ladies and gentlemen, what you're hearing is an understanding of what the defendant is claiming to have experienced, it's only to be used for the relevance of whatever, how it might have impacted him on the night of this particular incident you're here to try. So you're not to take what he said for the truth of the matter asserted, but only to relate it to any impact it may have had, what's going through his head with the incident where he was at Patton Towers and for the incident that happened in this particular case. That being said,
So have you experienced problems since then?
I mean, yes.
Okay. Let's go back to the night of September 28th, 2023. Is there anything about the event in 2013 and 2023 that explain your
I
actions?
mean, I have, like I said, I have trust issues. I was appointed on disability. I'm a cook by trade. And I was appointed on disability by a judge because I can't be around people like that. You know what I'm saying? I don't do boxing in spaces. I don't do people walking behind me. You know, the movement, you know, I'm constantly, you know, I see things that other people don't see and I hear things that people don't hear. You know what I'm saying? Sometimes. And it's like the movement is just, I mean, I can't really explain it because, but it's,
When you testified earlier, you said you don't remember.
sometimes I have trouble remembering things. But then, like sometimes I might see things from here instead of here. I see things from here. Makes sense what I'm saying?
I want, before we leave that, the issue of 2013, we were talking about the police coming out and talking to you. Were you released?
They released me, and they came and talked to me, and I explained to them that I had rented a room for one of the girls' friends. They went back to the hotel, rewound the video, and seen the person that I rented the room for. The person that I rented the room for was not the same person, and I rented the room on a Wednesday. This happened on a Saturday. The person I rented the room for was a different person than the person that robbed the place. So on the video, I never touched no money, never touched no key, no nothing.
Objection, Judge, this is irrelevant.
Were you charged?
No.
is there relevance? Is there relevance to this? What's the relevance?
Well, he's told a story. He was asking about police, and I'm asking if he was charged.
Ask and answer, Judge.
Overruled. You can answer.
Oh, back in 2013, after all that event was over, were you charged with a crime?
No. And then there was a lady at the Free Press named Beth Berger. She contacted me through Facebook. And she wrote an article published in the Chattanooga Free Press. And it was like,
Objection, Judge, this is irrelevant.
Get a little far afield, Mr. Little. If you want to, again, tie it to some event that has impact to the night of this incident, then you need to do that. Just a statement.
That we approached on.
Yes, sir.
have you had experiences since 2013 that have affected your thinking?
I mean, I developed drinking problems, and I hit but a wall one day in the county on some being drunk, or then for other drunk, that other drunk, like that, other drunk. And I was in it was strip search, and I hit but a wall, knocked myself out. So, I mean, if you talk about like a traumatic experience, I can't think of one.
But why do you think you butt your head on against the wall?
I don't know, I just got aggressive, just get angry sometimes, and just don't know.
When you're on the elevator in Patton Towers, the video we saw, you slammed your fist against the wall inside the elevator. What was that?
I just took somebody's life, man. You know what I'm saying? So,
And so that bothered
of course.
you. So this traumatic event in 2013, you had no control of what was happening once you were placed in handcuffs in the backseat of the car.
No.
So, did you have any kind of issues on the night of the 28th of 2023 about not having control and not what was going on in your head? Do you know?
I was fine up to that point where it just kept turning around.
Okay, where Mr. Wright kept turning around? Okay, and then, how did that affect your mind, your thinking?
And if I had to answer that, I would have needed a doctor.
So you don't know the answers to that. Okay. Yeah, just a moment, Your Honor. Since the event in 2013, have you had instances where you just felt like you were boxed in?
I mean, I pretty much, like, outside of going in a store or something, like Costco or Walmart or something, long lines, I can't do that. I went to Costco one day and I just had to leave. Because it's just like, people, it's just the movement. Usually I'm in the store and out the store. I go if I'm getting, I leave. I don't go in and browse. I don't go in and graze. I don't go in and shop. I go in, I know what I'm gonna get. I go in and get, I leave. I don't do long lines like Christmas, Black Friday, things like that.
So when Mr. Wright walked up on you, was just a feet or two away from you. What do you remember? What was your thinking or how you felt?
He invaded my space.
Okay, that make you feel uncomfortable?
Yes.
Did it make you feel anything else any other way?
I wasn't angry. I didn't know him long enough to get angry at him.
Right.
I just wanted him to leave.
Okay. And why did you want him to leave?
Because me and Vito, we was chilling. We didn't need him. You know what I'm saying? We don't know him. We don't know what he wants. You know what I'm saying? If he could, like I said, if he could introduce himself to us as Chris, it would have been a different outcome. But he didn't come and say, hey, my name's Chris. I've been drinking all day, bro. I'm just trying to keep it going. You know what I'm saying? I mean, if we felt like he was in danger of hurting himself, we would have called him. They catch people on the corner right there all the time. That Hillsborough.
No, you didn't. As it escalated, you said earlier, you didn't have that. What is Mr. Wright's tone, his actions escalated to you? How did that make you feel?
He wasn't loud with it, but I mean, I've been around, so I know aggression when I hear it in the first voice. From my daddy giving me whoopings, I know when I'm gonna get a whooping by the way he's talking. He's not letting everybody in the room know he's gonna give me a whooping, but he let me know he's gonna give me a whooping. When things are directed at me, I don't pick things up out the air. When things are directed at me, I pay attention to them. Just like the conversation between Chris and Vito, that wasn't part of my conversation, so I really didn't pay attention to it. The conversation between me and Mr. Wright wasn't Vito's conversation, so he really didn't pay attention to it. Chris didn't pay attention to it. It wasn't the point of him not saying it, it was the point of him not hearing it. pointed at me, he didn't point at Chris, he didn't point at Bill. He pointed at me. He told me I was a piece of shit. He didn't tell that to one of them. You know, so
So when he said that, when he said that, pointed you and called you a piece of shit, what did that do to you? Does that do something to you?
make me mad, really. No way to
Okay.
kind of
Makes you angry?
Yes, I mean,
Okay. Do you think that your response to him was related to your traumatic experience in 2013?
I mean, as far as the being aggressive part, yes.
Okay.
I mean, because I don't know what to do with that. Because I never was. Nobody never said, "Well, we apologize." Because if I was guilty, I went to jail. You know, they went back and looked at the video. They seen me rent the room for the person I rented for. They seen him pay the man at the hotel. They seen him get the key. They seen me get the money from him. He paid me to get the room and leave. That's why they let me go. The lady wrote the article. The police quit messing with me. You know, so I mean, I don't know what to do with that. You know, because I'm still like, it's like you put me in the back of a car with handcuffs on. Somebody get in and take me on and ask me to chase, like you put me in the trunk of a car. And there's no way you're gonna pull up on me by somebody I'm supposed to be able to trust the police. Makes sense what I'm saying? I mean, even though with a police record, I'm still supposed to be able to trust the police. As far as, you know, being able to not to be, you know, they just treated me like I wouldn't, you know, just like, well, hold him up here in Whitfield County. We're gonna prove he had something to do with it, but I had nothing to do with it. It's about, I mean, to a certain extent, it's about respect.
When he called you a piece of shit and the N words, did your condition or your thinking cause a traumatic
I would
event?
object, Your Honor.
Thank you, Honor. When he said those things to you, what happened in your head? Can you explain it?
No.
No. Okay. Do you understand? Understand how it works? How your thinking goes when you're confronted by somebody?
No, and I noticed in my days that I was getting a little aggressive, for nothing, and I tried to address that issue, but I never got that far down the line to figure out a solution. I wasn't like on appeals like that because they give me steering wheel make me drive. So I'm not trying to be one of the people sit around smoke cigarettes all the way down to the end of the filter. You know, I want to be lucid. I got a little intelligence. Right?
Just one, Your Honor. So thank you. Other questions I have, Your Honor?
No, Your Honor.
I'm sure you have any questions, Mr. Roberts? Council Roberts. Roberts, the jury has some questions. I'm gonna ask him if he could face the jury from answer. How tall are you?
6'6".
You turned yourself in on prior accounts. Why didn't you turn yourself in after this incident?
I hadn't had a chance to get my affairs in order. I didn't get the stuff. I was trying to find a way to get the stuff. I wanted to really break it to my family too. You know, my family clean people, and I didn't want them to hear about it to the news. I'd rather further back for me. And I didn't have my cat still up there and my personal property stuff in my apartment. So I just didn't have a chance to get my affairs in order yet. But the house I went back to was the house that was registered to probation. So it wasn't like that.
This is a similar question, but I'm gonna ask it anyway. If there's anything different about the prior incident, you can feel free to add it now. Why did you run?
Because I was trying to get my affairs in order. I wanted my people to know what happened. And then I was trying to get my mind together too. I didn't want to be there with that firearm. The police showed up because I wasn't sure what would happen.
Who do you feel started the confrontation?
This is right. He definitely started my affairs.
Can you redirect based on what the jury asked? Can you redirect from the defense? Can you recall from the statement? Very, very good.
You wanted to get your affairs in order. That's why you didn't turn yourself in?
At that time, yes.
Is that why you needed the burner phone?
Yes. So I can make phone calls because I got an iPhone, track iPhone.
So you wanted to just do everything on your terms and your terms alone, correct?
I mean, if I thought that, let's say King would let me do it, then I probably would trust him.
You would agree, sir, at 6'5",
6'6".
6'6". You are several inches taller than Chris Wright at 6'2".
6'6" to 170 pounds. Yes.
Nothing further. Redirect.
Okay.
Mr. Roberts, you may step down. Mr. Smith, Mr. Little, next witness.
Yes, Richard.
Sir. All right, members of the jury, there's some matters we can take up outside of your presence. Have you step to the jury room. Bring back in the room.
I swear from the testimony you're about to give is the truth, and the truth, and nothing but the truth, so help you God.
I do.
Judge, I'd ask that we incorporate the prior testimony as an offer of proof rather than going back through all of the information.
should be recognized as an expert in the field of forensic psychology. And the testimony she gave before will be taken into consideration for whatever point we're on now.
Good afternoon, Ms. Brown.
Good afternoon.
Thank you for coming back on such short notice.
Sure.
I understand you were testifying somewhere else this morning.
I was, yes.
Of course, we're here in the case of Darryl Roberts versus Darryl Roberts. You recall him.
Yes,
You had evaluated him at some prior point.
I did, yes.
And as a part of that evaluation, did you have an opportunity to interview him?
I did.
And during that interview of him, did you go over any mental health diagnoses?
Yes, I reviewed prior records that had psychiatric diagnoses and also independently made my own mental health diagnosis for him.
As we said prior before, the most recent one that you made was PTSD.
In addition to others, but that was one of the diagnoses I made, yes.
And what type of treatment had Mr. Roberts undergone for his various mental conditions?
He had treatment through the mental health court for many years. He also had treatment through volunteer behavioral health. And that was on and off beginning in about 2014 up until the time of his arrest.
During your interview of him, did you have an opportunity to discuss the incident that occurred on September 28, 2023?
I did.
What, if anything, did he tell you about what triggered the incident?
He told me several things. He told me that he kept saying he didn't know what this person could do or what their intent was, essentially. He said that he encouraged Mr. Wright to move on, and when he didn't, he felt that that was a potential challenge or threat to him. He also talked about how he sort of didn't know him, hadn't seen him before, wasn't sure if he was armed, didn't know what kind of threat he posed, and he hesitantly talked to me about racial slurs that he said were made to him by Mr. Wright.
Did you follow up on that, or did you move on from that, or how do you handle that?
We did talk about that. What he said was, initially, like I said, he was hesitant to discuss this with me and said, I don't want it to be about race. And as we continued to discuss it, he indicated that Mr. Wright had called him the N-word twice, and that dehumanized him and really got to him, and increased the level of threat that he perceived.
When you talk about threat perception, did you discuss with him how he normally perceives threats, or the manner in which he perceives threats?
Sure. He is readily admits that he is reactive, that the way he describes it is he goes from 0 to 100 quickly. He is quick to perceive that others are a potential threat for him. He's on guard often. He's what we call hypervigilant of his surroundings, very watchful, very, very cautious.
Did he mention anything to you about the lung conditions?
Conditions, yes. He indicated that he has COPD, that he has had treatment for that, including, I believe, surgical intervention on his lungs as well. He's had that condition for many years.
Yeah, we want-
No further questions, Judge. Argue. Thank you, Dr. Grant.
Okay, may I be excused?
Well, we may need to. Okay. So, if you want to go ahead and have a seat in the hallway, we'll call back.
Thank you.
Mr. Smith, I agree with your assessment that credibility of the racial slurs was raised. It was credibility of the defendant's story about racial slurs being uttered by the victim was attacked on cross. Under the law, you do get to call someone to provide a prior consistent statement. Will also be given a limiting instruction, just like impeachment is not to be used for truth matter asserted. Prior consistent statement will not be used for the truth matter asserted, only as it relates to client's credibility. Anything else beyond?
May we be heard?
Yes.
Can I ask where the credibility was was attacked?
When Mr. Roberts was asked several times about him being the only source of the racial slurs, how the two people very close by him who would have heard them perhaps did not report that. So that the court's estimation is questioning the veracity of Mr. Roberts' statement of racial slurs.
Judge, the court, we had a statement we could have impeached him with, and he never said that to law enforcement. We didn't do that. We also never said that he just concocted this right now. The only thing that General Moyle extracted was that he is the only author of that statement. I'm having a very difficult time seeing how one to introduce a prior consistent statement when the individual has not been impeached on that statement. Just said, you're the only person that says that.
I thought he was impeached quite thoroughly. I mean, he was impeached by two people that were apparently right there with him, never said it to the police. But General Moore was pretty clear about how he was the defendant, is the only source of any type of claim that the victim used a racial slur.
Correct.
That's in the context that was brought out. It was clear that it was, whether it was intended or not, I don't know. I take what the effect was, and I called into question the credibility of Mr. Roberts saying that.
Okay. Judge, how can the state then bring out that the defendant never said that and when he met with law enforcement? That would have been the way that the state would have impeached the defendant. We didn't say that he said one thing and then he said another. It's just that you're the only person that says that. I don't see how that is the same as impeaching an individual.
Just two people who were sitting right there at the same time, who apparently would have certainly heard enough of the conversation, though they feel threatened by it, did not hear these racial slurs. The fact that they did not hear the racial slurs when any person with normal hearing in that vicinity of the conversation would have heard them. I think the takeaway is, the state's point is that insinuating that they were never said.
Correct.
That the defendant's making that up. That's impeachment of his credibility.
Yes, sir.
All right, anything else?
The issue of the COPD was impeached slightly. We talked about the stairs.
That calls for a medical conclusion at some point. I don't think it goes beyond this witness's expertise.
Okay, I I'm just saying that he made that report to her, or she found out that information.
I don't think that's in the same category of him supposedly making something up. It's more the condition of how severe is his COPD versus.
Good call, Stephen Grant.
Yes, so you have to be careful when you direct her. You're gonna have to ask her, in her employment, that she sometime interviewed people charged with crimes. During this interview, did you interview the defendant, Mr. Roberts? During that interview about this incident, did he mention anything about racial slurs? That's it. And I'll give the jury the limiting instruction that's only used for credibility. All right. All right, so she'll be referred to as Kimberly Brown or Mrs. Brown, not Dr. Brown. Okay? I don't want the jury to have any speculation about whether she's a medical doctor, if she's a PhD, so she'll be referred to as Mrs. Brown in this case.
I'm afraid that she is used to testifying as a doctor, so even if I do that, I certainly will try to do what the court says.
Go bring her in. Bye. Dr. Brown, I know you travel all across the state, probably all over the southeast, for lots of different reasons. Thank you for being here. We certainly appreciate your availability to help in these cases. This may be the shortest testimony that you've given. You're limited to just a couple of points. You're not referred to as Dr. Brown, but Mrs. Brown for this particular point. It's only for the statement that the defendant gave you that racial slurs were used in this incident.
Correct.
Okay.
Yes.
So you're referred to as Mrs. Brown, truly no offense, just to make sure the jury doesn't have any speculation about what that means. So you referred to as Mrs. Brown. We asked about your employment. As far as like in the course of your employment, you interview defendants, charged with crimes. In the course of your employment, did you interview Mr. Roberts? And then during the interview about this incident, did he say anything about racial slurs being used?
Okay, I understand now.
And that's it.
Yes.
Judge, are we allowed to ask about him forging military documents to her? He also admitted that to her. Yes, sir. He indicated he was in a fight and twisted his ankle, later forged a document regarding this incident. He was placed in the Army jail for forgery for a few days and was unsure whether he was at Article 15. He stated he was dishonorably discharged.
That wasn't in the state's notice of impeachment. But it was testified. I think notice of impeachment includes prior convictions or acts,
And we did not present that.
and it wasn't in the notice to the defendant.
Judge, she's being called to say that a prior consistent statement. I'm not impeaching the defendant. He's not on the stand.
All right, tell me your argument.
She is being asked if he said something before him. And it's being done for the purpose of a prior consistent statement. My understanding is that we should be allowed to ask her about things where he was not honest or where he admitted to being dishonest.
Okay.
We're not in,
So I guess remind me where did Mr. Roberts direct or cross that he said something that was contradicted by Dr. Brown's.
the judge, it goes towards a prior consistent statement, so I think the state should be allowed to get into prior dishonesty that this specific witness extracted from.
So that's what I thought originally, to make sure I was following.
Yes.
If during his testimony, he said something that can be impeached, then you can certainly do prior inconsistent statement. If he has engaged in any dishonest behavior, whether it's this particular witness, whether it's, lying at the job or something that he was not charged with. I do believe that has to be in a notice that you're going to impeach him with that. So if he did not say anything that opened the door to it, I think he's entitled to have notice before it comes in. Well, it might have impacted on his decision to testify. So, no, you may not get into that.
Yes, sir.
Any other issues before bringing the jury? Bring the jury.
That's fine.
All right, please be seated. Mr. Brown may remain standing throughout the court.
I swear from the testimony you're about to give the truth, the whole truth, and nothing but the truth. Have you done?
I do.
Mr. Brown, good afternoon.
Good afternoon.
I understand that through your employment, you have a reason to interview defendants in criminal cases. Is that correct?
That's correct.
And do you recognize Mr. Roberts here?
I do.
I want to direct your attention back to an event that happened on September 28, 2023.
Yes,
Did you interview him about that event?
I did.
And do you recall what date your interview was?
Yes, my interview occurred on October 2nd, 2024.
So at some later date, you interviewed Mr. Roberts. Did you have an occasion during that interview to talk about specific facts or occurrences that happened on that day?
Yes,
And during that interview with Mr. Roberts, did you have an opportunity to question him about the triggering event that led to the altercation, the confrontation on the night of the 28th?
yes, we did discuss that.
Okay, and what did Mr. Roberts tell you?
Mr. Smith, please be more precise with your question, okay?
What did Mr. Roberts tell you about any racial nature of the triggering event, if in fact that was what it was?
Yes, Mr. Roberts told me that Mr. Wright had called him the N-word twice, and that really got to him, and he described it as dehumanizing me.
And one moment, Judge. Thank you for your testimony. Can we move forward?
You cross.
Yes, Judge. Had, you worked with Mr. Roberts at the request of defense counsel, is that right?
Yes,
You met with Mr. Roberts for the first time in October of 2024 at the request of defense counsel, is that correct?
yes,
Mr. Roberts did not say anything about a racial slur to you prior to you being requested to interview him by defense counsel in October of 2024. Is that right?
that's right. The first time I talked to him was October 2024.
Thank you.
Ladies and gentlemen, this witness was called for a very specific purpose for a very limited line of questioning. It was brought out in Mr. Roberts' testimony about cross-examination about he might, it was questioned whether the racial epithets were even mentioned. So this is what's called a prior consistent statement. It simply is to be used to show, to reflect upon Mr. Roberts' credibility that he did say that he did tell someone about racial epithets before he testified today. It's not to be used for the truth matter certain. It's a little complicated, but you cannot use that statement from Mrs. Brown that the racial epithets were actually said. That would be for the truth matter certain. However, you can use it to gauge Mr. Roberts' credibility that he actually told one person about the racial epithets.
Judge, may I approach?
Yes. And again, just so there's no confusion, you are the judges of the credibility of all witnesses, from Mr. Roberts to Mrs. Brown. Okay? Thank you, Mrs. Brown.
Thank you.
Mr. Smith, Mr. Will, call your next witness.
I'm sorry, Judge, I'm gonna interrupt.
Yes. Ladies and gentlemen, you may recall when we started on Monday that I said we hope we finish on Thursday. We're not. So what that means is that it's 10 minutes after 5. You're going to have 3 days where you cannot let yourself be exposed to any media about this. You can obviously tell there's been media courtroom that you cannot let yourself be exposed to anything. So you're going to have 3 days. Maybe it's a good thing. You can't watch TV. You can't listen to the radio. You can't go online the way you used to, perhaps, to look at news. You don't know what's going to pop up. There has been a lot of coverage on this. So you're just not going to be able to do that. Okay? So with that admonition, again, not only refrain from being exposed to media, you cannot form any opinion about the case, you cannot talk about the case, or let anyone else talk with you about the case. With that admonition, I'm going to release you until Monday at the same time. Be here at 9:15. Hopefully start around 9:30. Took a break about an hour ago, it's an hour and 20 minutes ago. We're going to get into some long involved aspects of offer proof and also kind of working through instructions. The parties need a break now, you want to consult your own for a little bit.
Fine, John.
All right, so you're out for
That's the purpose of putting an offer proof on for, Paul Strong. So, since it was read as 103A2.
All right, raise your right hand. Someone's ready. Everything about the truth, the whole truth, nothing but the truth, so help you God. Yes, sir.
State your name again.
Darryl Roberts.
Good. Mr. Roberts, what led you to live in Patton Towers?
I was homeless. I got, like I said, I get disability. I had a Section 8, but I couldn't find nothing on the Section 8 due to COVID. Everything was a year or 3 years waitlist. And the house I was staying in Brand, they were shooting it up. So Brand got so weird, everybody.
So, who helped you get into Patton Towers? Mental health court?
Yes, sir.
How long were you in mental health court?
7 years.
7 years. You graduate?
Yes, sir.
It's a long time.
They never gave up on me.
And so, what are the requirements, or what type of tenants live in Patton Towers?
Most of the tenants with some kind of form of disability, like beat over the one eye, the days on the walker.
Okay. Any other conditions that,
Mental health problem.
mental health
Yeah,
problems?
schizophrenia. The lady with schizophrenia. I guess it's because.
And so, you have a disability check, I understand. What is it for? You mentioned earlier.
It's mainly because of the mental health.
Okay. And what is your mental health?
I was, according to the diagnosis with PTSD and it's some kind of explosive disorder.
And so, and that was something you dealt with while you were in mental health court?
Yes.
And how long have you suffered with those mental health issues?
I mean, I guess I probably have them somewhere down inside me my whole life, but I think that it's been in 2013 going out.
And you've been treated for mental health issues?
Yes.
Tell the jury about where you've been treated at.
Johnson Mental Health, mainly Johnson Mental Health, and of course Mental Health Court.
Any others?
I went to Helen Rock McNabb for a brief second, but
were you at any time prescribed medication for your mental health issues? Are you prescribed mental health medicine now?
Yes,
What do you take?
I take taxes now.
Paxil. So when did you discover that you had PTSD?
I never really knew the diagnosis on it until pretty much I got in trouble.
Okay.
I just knew something was going on. And if I was told, I don't remember. But I know with the medication, somebody might have said, hey, this is PTSD. Like the Wellbutrin might be PTSD medication. Seroquel was sweet because my mind kind of shut down.
Yeah, and I've already asked you about the traumatic event of 2013. Do you know do you have PTSD symptoms every minute, every day, or do they come and go?
I mean, the aggression is only, like, I don't walk down the street and kick a rock and get mad. You know what I'm saying? I might hit my head or something, it might frustrate me. But, like, the only thing that's really consistent with that is probably the depression.
Depression? And that night at Patton Towers, did you feel any of those feelings that you experienced with this mental
I was
illness?
pretty much going through it when I came down.
You came downstairs. When you first came downstairs. Just a moment. Are you always on alert?
Yes.
Are you at times jumpy? When I think about jumpy, nervous reaction sometimes?
Yes.
You feel like you're boxed in?
Yes.
Overreact sometimes?
Yes.
Do you overreact to certain events?
There's certain things, like I'm not very argumentative. I don't argue well. You know, like as far as a woman, man, I don't argue well. I'm not arguing well.
When I asked you earlier if you're always on alert, have you been threatened in the last, say, since 2013? There were times you've been threatened?
Yes.
And how would you react when you're threatened?
I don't know, it depends. I mean, it just wasn't, most of the threats passed, you know what I'm saying? And I was able to think about it. But like I said, that night, I don't know why, and I can't explain it. But I don't know why, because I mean, if I thought about it, I would have done it. You know, because I knew better. I knew the counter work, I knew what it was going to lead to, and everything I worked with. So I wouldn't have done it. But I don't know why that night, particular night, it just like, wasn't no control.
You said no control?
No control.
You had no control.
Over my thoughts, my actions.
Yeah, that's all the question I have. Mr. Roberts.
Okay.
Add any additional comment beyond what was argued in the earlier motion based on how we're.
Judge, I think if I'm off clear by somebody clear why I'm off. I appreciate that. I appreciate that. You know, I think we as a defense judge, we feel that that's relevant. We feel that's relevant. And the reason we feel it's relevant is because, first of all, it shows why he's living in Patton Towers, why he's sitting on a stoop at night, why he was homeless, why he has a criminal record, why he spent 7 years in mental health court, How an individual punch his fist on an elevator while he's going up the inside the elevator pad towers. That was evidence produced, and we cannot, they can argue at trial. I mean, in closing that they can say he did anything. We can't, he can't explain he's got PTSD and that's why he doesn't lose his control. Of course, we know why he has PTSD. That's already been. So, I guess, and I know, of course, PTSD does not eliminate the capacity. We know that for premeditation. We understand that under Hall. We've always been arguing that the evidence shows that Mr. Roberts was minding his own business that night. He'd been out there since 12:30. People coming and going. He was talking to his friend, another neighbor. No issues whatsoever. None whatsoever. Until Mr. Wright shows up, drunk, starts pointing his finger, pointing his arm at a man who's got PTSD. 12 o'clock at night. And it escalates. He keeps turning around, talking to us, and it just puts Mr. Roberts in a place. We cannot explain that to the jury. And this is a mens rea case, Your Honor, and we can't get into Mr. Roberts' brain. Okay. Thank you, Your Honor.
The court, after hearing the offer of proof, this thing about earlier ruling where PTSD or bipolar or intermittent explosive disorder, those are admissible sometimes when there is an expert who is able to say with a reasonable degree of scientific certainty that the disorder removed the defendant's capacity to form the required mental state. So that was not present in this case, and that's why the court excluded any reference by professional expert testimony of any type of actual diagnosis. The offer of proof also today included the fact that Mr. Roberts has been in mental health court, been seen by Joe Johnson, seen by Helen Ross McNabb, prescribed mental health medication. That too gets too close in the court's opinion to establishing what I think the court has excluded, the appellate courts have excluded, that these diagnoses, I'm not saying they weren't there, I am saying that they did not rise to the level to remove his capacity. So that's why the court laid the ruling earlier in, I guess, included, since you brought it up today, the mental health court aspect, Joe Johnson, Ross McNabb, and prescription of mental health medication. So the same by saying ruling that there's a clear distinction between a professional providing information about this versus a lay witness providing testimony about specific instances that they've seen. What's unusual about this case is that Mr. Roberts is, of course, a lay witness, but he's also the defendant, so he would, under the law, the court's reading of it, not only be able to do what a lay witness could, and that's describe prior traumatic instance, but also to provide how that instance affects his thoughts, emotions, and actions. So he does get that additional leeway for that, but it does not rise to the level that it goes against the appellate courts and Supreme Court's ruling that expert testimony can only be admitted when it's been established that it does not have the capacity to form intent. This court stands by its earlier ruling. Arguing jury instructions? That next on the list? Yes, sir.
Judge, I believe the flight concealment within our community has been fairly raised by the proof. The defendant left the scene. He is attempting to, and I think he said it more today. It was his decision to flee the scene. He wanted to leave and get his things in order. We have text messages where he says, "I just smoked somebody. He's looking for burner phones."
No, I hate to cut you off. I think I'm doing this the wrong way. I think there is evidence in the record where flight instruction is warranted, so let the defense argue against that. I also think there's an inference from concealment of evidence when he admitted today about destroying the gun.
We read
You
them.
get to argue that if you wish. In the court's position at this point, that I don't think self-defense has been fairly raised. Looking at state events and giving the defense time to look at this and argue this more completely if you wish. Looking at State v. Benson, say DC Supreme Court case 600 Southwest 3rd, 896. In this particular case, the victim punched the defendant, and the defendant shot and killed the victim. And the court found that it was not fairly raised that the issue reasonably feared imminent death or serious bodily injury. And this seems to be even further on the side of that ruling, where there wasn't even an assault. So at this point, the court feels that self-defense has not been fairly raised. So at this point, I'll let the defense present their positions.
Judge, if you don't mind, I have time to read that case.
Yes, sir.
You did that on Monday morning. Judges can fly. I think the testimony was that Mr. Roberts left. He went to his former, not home, but where he slept in a truck. He did make communication via electronic communication, said that he needed a burner phone. What he explained that he wanted to do was take care of his affairs. He'd already talked to Detective King that morning. He answered the phone. Detective King talked to him. I'm not sure what that conversation was, but they did talk. And he was worried about his pet, as he testified to. There's no indication that he was going to leave. He didn't leave. He was still in the city the next day, wondering how he needed to do it, how he needed to turn himself in. I would ask for flight instruction not to get him.
From his lips, he said that he wanted the burner phone because they can track an iPhone. He left the scene of the difficulty for parts unknown to law enforcement. Candidly, if the court would like a proffer proof, the assertion that he spoke with Detective King is categorically false. And I'd be happy to call Detective King under oath to put on proof of that. But he fled the scene, he concealed evidence, and he obfuscated and attempted to hide his tracks by getting a burner phone, which he explained was to avoid detection and tracking. That is per se flight. It has been fairly raised.
Yeah, I tend to agree, Mr. Little, that it's been fairly raised. You can certainly argue that it was not meant to be a complete withdrawal from the jurisdiction or hiding out until police arrested him. You can argue that, but as far as getting the actual instruction, I think it's fairly raised there. The proof is that he certainly left the scene of the difficulty, which is the scene of the actual shooting. He changed clothes, whether he asked her to or not, for whatever reason. This lady took his clothes. He said he thought about it more, that he might have kept the gun and given it to the police later the damn mistake, but he didn't. So, and of course, the text messages talk about how he needs a burner phone. The court interprets as a phone that's So I know that the state used the defendant's statement briefly to impeach him. Does that not have in your hand when you're impeaching him about what you told the police about getting so close? You had something in your hand.
That was his statement to the psychiatrist.
Okay.
Yes, sir.
Curious how there needed to be an instruction that dealt with the prior statement of the defendant for impeachment. I was thinking it was the prior statement against the police, but it's the prior statement against the psychologist. I don't know if that really changes it.
Your Honor, would recall we announced that we would not be using the prior statement for law enforcement. Because counsel filed a motion to suppress.
You did, and I think you said unless.
So we abided by our assertion.
Yeah, you said you were using your case in chief, so I just make sure the impeachment.
We never ended up using it. I don't know that that changes the analysis. I feel like just to be safe, my position, our position would be to include that in the jury instructions.
You read that charge, Judge?
It was just impeachment. So the prior, what I'll do is I'll email the parties, you can look at it, if there are a number of instructions with the prior statement of the defendant.
The problem I have is that he asked him about it, but he didn't show it to him to refresh his recollection. He didn't refer to it as his prior statement. Just merely had it in his hand. I don't know that, I think it will confuse the jury because the defendant's prior statement never came in except for what Dr. Brown testified to.
Which is the same statement.
So you're saying that there shouldn't be an instruction on a prior statement of the defendant at all?
Well, I need to see the instructions.
Okay.
I believe the exact question was, Trivich previously said, whatever that would be a prior statement. I have that.
Okay. All right, we can look at that over the weekend, long weekend, I guess, or at least early Monday morning. Any other jury instruction comments or issues that you want me to look at between now and then? Okay, so the letter work is, we'll argue these on the self-defense on Monday morning at 9:30. If the defense rests, the state be calling them over.
Judge, I don't think so. I think what allowed us to call rebuttal proof is if the court accepted him as the first aggressor. That would open the door for individuals, good individuals, to say that he would never have said those racist comments. I do not believe that the state, that would be consistent with the rules without a self-defense instruction. That's my reading of it.
Okay, so next step would be arguing the jury instructions, see where that leaves us, and that will let us know how to proceed. Assuming that no other evidence is necessary, the jury instructions, I'll finalize them, I'll get a copy of them, go over them one more time, bring the jury in, pencil rest. I'll read the preliminary jury instructions, the long ones. I'll think both sides will close. I'll do a brief instructions at the very end of the break, and we'll get into the bifurcated aspects after that.
Thank you, Judge.
All right. That for that one. Court's in recess till 9 a.m. on Monday.